Hello, everyone. I'm Kevin Gosztola, managing editor for Shadowproof.com. Here on day 15, we've just made it to the fourth and final week of witness testimony, and we went through two witnesses. Both of them were brought by the defense to testify on the U.S. prisons as well as U.S. jails, specifically to try and convince the judge that the conditions at facilities where WikiLeaks founder Julian Assange will be held are inhumane or would present a risk to his mental and physical health, perhaps increase his risk of suicide if he was put into these facilities. We heard evidence involving the Alexandria Detention Center, which has already received a place in the story of this case because it is where PFC Chelsea Manning was held when she refused to testify before the grand jury that was investigating WikiLeaks. And so we have these two witnesses that came today, which I want to get into. We had Yancey Ellis, who is someone with a background as a public defender working in the very district and area where Julian Assange will likely be put on trial, working in the area where he is likely to be confined at the Alexandria Detention Center. Yancey Ellis is somebody who has represented people who were confined at this facility. And so he was able to speak to specific details and share specific information. We weren't just talking about the policies. We weren't just talking about the supposed procedures that the Bureau of Prisons would follow, or that that a jail would follow, or that someone who is in the U.S. Marshals custody, as Julian Assange would be if he is confined at Alexandria Detention Center. We were talking about reality as it would exist within this facility should Julian Assange be confined in pretrial confinement, should he be held in pretrial confinement. So what I mean by that is specifically an example that we've gotten from Assistant U.S. Attorney Gordon Kromberg. Repeatedly, this has been mentioned by the prosecutors that if Julian Assange was in the Alexandria Detention Center in administrative segregation, which is essentially the words the U.S. government uses for solitary confinement. It's their euphemism. They maintain that there isn't solitary confinement at the ADC, but there is administrative segregation. And one thing we've heard over and over again from Kromberg is that an inmate would be able to communicate with other prisoners through doors and the windows of their cell. And what we heard today from Mr. Ellis was that you do that, but you would have to scream. You would have to yell at the top of your lungs. It would be difficult to carry a conversation. The idea that you would be able to carry a conversation through a food slot is also far-fetched because the correctional officer, you may close that slot. So it's not necessarily true that it would be available. The entire point, as Ellis noted, was administrative segregation exists to prevent prisoners from associated. The very reason why you are being put in those conditions is because they feel it would be dangerous for you to be forming associations with prisoners in general population. And so you are put in administrative segregation for your safety. Not only does it control your communication outside the facility, but it is also controlling the way you are able to influence and speak with prisoners inside. It's so that they can better control the facility and control you as a prisoner. But this idea, this ludicrous idea that you would be able to talk through these steel doors, even Yancey Ellis was able to specifically, I think, show that this is something that needs to be put to rest. Obviously, I don't necessarily believe the prosecutors will stop repeating it simply because one has proven it impossible. But I tell you that he very clearly informed the court what it was like, and I believe that he brought something to the conversation that was good, because so far we'd had a lot of conversation that was figurative and was not based in experiences from people who had gone inside of these facilities, with maybe the exception of U.S. Attorney Eric Lewis, who was brought to the witness stand by the defense several days ago, maybe around 10 or so days ago now at this point. But he was only testifying about the sentence that Julian Assange would likely receive. He was only able to give minimal evidence about Alexandria. He didn't have a whole lot of experience. So having somebody who's a public defender who has represented people who are held in this facility, which is a state facility, it's not a federal facility, but the federal government has contracts so that they can house people here during pretrial confinement. And it could take a really long time to get through Julian Assange's sentence, pretrial, to get to the trial too. It could be maybe 1 to 2 years. And that's a lot of time to be put into conditions of administrative segregation, or, to be appropriate here, solitary confinement. And then in the afternoon, or following Yancey Ellis, what we had was a witness who was put on the stand named Joel Sickler, who has some experience representing people as an advocate. He runs something called the Justice Advocacy Group, also does work in Alexandria, Virginia. He's involved in mitigating. He'll represent people and try to help them get their sentences down, also help them with their placement in facilities, how they might be able to make representations so that they could get put in a facility that is the least harsh or least horrible for them as they serve out their sentence. And in fact, he had been consulted and used in the Reality Winner case, which came up during his cross-examination by the prosecutor. So he shared his experiences visiting federal prisons. He brought up some of his knowledge of the way the Federal Bureau of Prisons functions. And he was brought forward to speak about the possible solitary confinement in the Alexandria Detention Center, and also to speak about the kind of psychological trauma that would be done to somebody in solitary confinement. His submission to the court went into some great detail about Julian Assange's mental and physical health, and that he connected it to what would happen in those facilities to Julian Assange as a result of his diagnoses. And then he described the programs that are available to somebody with mental health issues, and how BOP does not necessarily address those when prisoners have issues and problems. And so he was a good witness to call to the stand. However, I do have to say this is the first witness in which I think it may not have gone as well for the defense team. I had the sense while watching him that he was very apathetic about the questions that were asked by the prosecutor, that he was growing tired. It wore on him. They took about 2 to 2.5 hours asking him questions. He didn't seem to have much appreciation for what the prosecutors were trying to do, even as he was clearly an advocate who did not agree with their approach to how they defend and justify the Bureau of Prisons and the way they confine inmates. What we got from Claire Dobbin, she was the prosecutor that led this cross-examination, was a kind of an argument that looked like a cross-examination. She was asking questions she was putting things to Joel Sickler, but he didn't really know what she was referring to, because it came from a bundle of material that like all prior witnesses, was given to him less than 24 hours before this cross-examination. And so what she wanted to do, the reason why they take so much time, is because he put himself forward as an expert witness. He took the stand as an expert. And so the prosecution is challenging whether or not he's truly an expert on U.S. prisons and jails and the things in which he says he knows about. And that's all fair, except she was asking him about things that he didn't even bring into the work. He didn't bring into the testimony that he submitted to the court. So they're going outside of what was even relevant to his testimony. We saw something like this happen earlier in this extradition trial with Kerry Shankman, a U.S. attorney who is an expert on the Espionage Act. And he ultimately was grilled about case law that at least he could speak to, but it wasn't necessarily crucial or a part of the work that he had done on the case. And so here we had them occupying a lot of time in this extradition trial. The prosecution did, going through reading Bureau of Prisons policies, reading Bureau of Prisons guidelines and practices, claiming that this is what is laid out, looking at reports and reviews, looking at recommendations from reviews related to how prisoners with mental illnesses are handled, claiming that the Bureau of Prisons agreed to adopt these recommendations, so all must be well in these facilities. And he kept coming back with this fact that I just haven't seen it in practice. The clients, the people who I represent, don't seem to be doing as well as you claim. You say that this is what the Bureau of Prisons is supposed to do, and that's all well and good if you've got more staffing and everything, but there's just no experience. And I will say that one of the more, as I reflect on what happened, because it was very excruciating to watch, I found it to be one of the hardest cross-examinations to tolerate, because he didn't really have much to offer of use, and she insisted on continuing with the cross-examination, even though there wasn't anything that could be gleaned through the questions, and she was using him basically as a way of entering a lot of information, getting a lot of information before all of us about how they think the defense's arguments about U.S. prisons and jails is complete and total nonsense. And so ultimately, I felt like it was wasting our time because there wasn't anything concrete to really dig into. A lot of it was abstracted, and I know that prosecutors aren't going to agree with what the defense is saying, and I know that they want us all to believe that Julian Assange should be treated humanely if he is brought to the United States and put in a pretrial confinement, or put in or when he's sentenced to a prison, that they would take care of his basic needs, as they claim that they take care of the basic needs for all prisoners. But that is not proven out by the facts. The facts don't show that that's how people are handled in the United States, which leads me to be very irritated by a line of questioning that goes on and does not allow for the person who is the witness to engage in those questions, because he doesn't have any understanding of the material. So because you're putting questions to somebody who is uninformed about the subjects, not because he's stupid, not because he doesn't care about it, but because he hasn't seen these materials yet until less than a day ago, which he's supposed to somehow talk about as an expert, we get what we witnessed. We get what was tedious, and I think the judge could have intervened and said, move it along. He does not have answers. It's clear he's not familiar with these terrorism cases. So, I get it. Move on to your next thing. We don't need 2.5 hours. You could take much less time with this person. But there was a exchange that came up that I note, which was rather important to me as I look back, because Joel Sickler was asked. So he shared a story about a prisoner that he represented at the Metropolitan Detention Center in Brooklyn, and that they had a serious psychiatric disorder that prison administrators ignored, even though that prisoner tried to notify them of his condition. The prisoner acted out and was severely beaten by correctional officers. They then threw him in the hole naked. His condition remained untreated, and then he was ultimately authorized. There was a court intervention, and he got moved. So he was released by the federal government, and then the state took him into custody so that he could be in Bellevue Psychiatric Hospital for some treatment. So he was essentially institutionalized for mental health treatment. And for Claire Dobbin, the prosecutor who was digging into this, first off, she's not from the United States, so she didn't appreciate the difference between federal and state. And then after that ignorance was played out, then she justified the brutal treatment that this person experienced being thrown in the hole naked, and essentially said, hey, it's judicial oversight, and the system had worked. And this is so, to me, we can carry out this to its logical conclusion. If Julian Assange has a mental episode, a severe episode of depression, and breaks down, has some kind of a psychotic breakdown, and he might end up acting out a little bit, or he might say something that gets under the skin of a correctional officer. He could be beaten. They might take all of his clothes, throw him in the hole naked, just like this person, and he could try to appeal to the state, but I don't know that he's going to be able to, being that he came from overseas. But who knows? Let's say maybe he's successful. He gets put in a psychiatric hospital that isn't controlled by the federal government. I'm not sure why they would give up custody, but let's just carry it through to this absurd example and say that this all works out and he ends up in a state psychiatric facility. And I don't know, maybe after he's treated, they'll turn him back over to finish his sentence in a national facility. I'm not sure how any of this works, but the bottom line here is, if this unfolded and he went through this kind of abuse, Claire Dobbin's position is that the fact that courts are moving prisoners around and getting them attention, that this is all good. This is all how the system is supposed to handle people who are defendants or are prisoners who have been sentenced for offenses. And so this is, to her, reason to ignore everything the defense is bringing forward about the kind of abuse that Julian Assange could suffer, which is, I probably don't have to do a lot to persuade you in figuring out that is ridiculous. So I have some questions to answer, and then I'll probably wrap this up. We've got some more prison testimony that will be coming tomorrow. We have a former Bureau of Prisons warden named Maureen Baird, who has been referenced throughout these proceedings. Oftentimes we've heard Maureen raised when trying to rebut the testimony or the affidavit that was submitted by Gordon Kromberg, the assistant U.S. attorney who is in the Eastern District of Virginia, who has been making representations about how the Bureau of Prisons treats people and how the Alexandria Detention Center would treat someone like Julian Assange. And I think notably, Gordon Kromberg is never going to take the witness stand in all of this. The prosecutors didn't call him, and it's not possible really for the defense to call him as a defense witness. He's a hostile individual in all of this, and so he would agree to do that for the defense to make himself available. So we've got all of these written statements from Gordon Kromberg that that the defense cannot cross-examine. So they had to find somebody else, and I think they've probably hit on somebody who has credibility and can speak to a lot of these issues as someone who was a Bureau of Prisons warden. Now, what they're going to do is try to say that you're not at the facilities where this defense is claiming Julian Assange will be incarcerated. They'll do that to try and discredit her testimony, but still, she's somebody who came from inside of the system, and she'll be able to address these things. So she'll be able to address these issues related to prisons. So I appreciate all the gratitude. I appreciate everyone out here who is thanking me for this reporting. So I wanted to say that before moving too far on. And I see somebody thanking me for appearing on our trashy Aussie Sky News. Hope it gets some traction. Let me just say that there's a producer there who has been very kind, and I enjoy working with him. And he's followed my reporting, and I'm glad that I've been invited to give updates on the network. I don't live in Australia. I don't watch Sky News Australia. I can't do a full media criticism or / breakdown of the network, but I can say that I've had the opportunity to connect with somebody who seems to care about the work that I'm doing, and I'm glad that they've given me a chance to share it with people in Australia. I see something about the defense should address the prosecution's redundancy, the time wasted. I'm not concerned that the most crucial of testimony is going to be lost, that they're going to have to give up bringing witnesses that really matter, like the witnesses who want to testify or will testify about the espionage operation against the Ecuador embassy. But, they want to take 2.5 hours, 2 to 2.5 hours with I think each of the witnesses that are to come tomorrow. At least with Maureen Baird, they want 2.5 hours again, the prosecution. The defense only gets a half hour, and then they hand it over, and the prosecutor gets 2.5 hours to read Bureau of Prison guidelines and regulations to someone, and they get to deny reality and pretend like this is the way it is actually done, when the facts on the ground are completely different. It's essentially reading propaganda to the witness and saying, what do you agree with? Do you agree that this is what our regulations and guidelines are? Well, of course I agree that these are what the regulations and guidelines are in the Bureau of Prisons. That's what it says on the page. What does that have to do with how a prisoner gets treated by people who are in the custody of prisons? And then Claire Douglas keeps calling it the BOP. And it's like, okay, the absurdity and the way in which this is playing out becomes harder and harder seriously, because you won't say the acronym. You won't say BOP. You say BOP. It's the BOP. The BOP will put Assange in the solitary confinement. Oh, okay. And all right. So as I got Scott Murdoch, be careful. Okay. Well, here's the thing. If I'm ever told to say when I go on TV, when I'm ever told what to say on TV, that ever happens, then I'll beware. But so far, I get to do what I want to do and say what I want to say. So I'm not going to turn down the opportunity to speak to an audience about my reporting. Is the ruling written already? What do you think? I presume that an extradition hasn't been authorized. I do not know. I'm not sure that anything has been written yet, because there aren't any closing arguments that have been submitted to the court. So there's a lot to still go over. One more question here from Boris. How can this work? How are you kidding or what? When you're jailed and innocent, how can anything work? The general frustration there, I understand. I don't know how bad the blackout is on ABC in Australia. Chaz appears on Sky News as well as Planet America on ABC. Maybe he can get you under the government wire. Again, like, I have to say that there have been people with Sky News Australia. There's been this producer who's reached out to me. I'm grateful for it. I'm not getting any attention anymore from anyone at the BBC or any person in the UK. Perhaps that has some meaning. And nobody here in the United States is really contacting anymore. I've done most of the independent media that would reach out and talk to me. I've spoken with them, and being in the fourth week of this extradition trial, I'm sensing the fatigue. Most of these media institutions don't have much interest, and as these things wear on, they come and they go, and they don't really care. This was the way that the Chelsea Manning trial unfolded, because you remember the Chelsea Manning trial that in 2013 took from June all the way well into and to the end of July. The verdict was read out on July 30th. And definitely for that, even as high profile as that was, I could not say that there was media there every day. We had a ton on the first days, then it thins out. People don't really pay much attention. And then they come and they go as there's witnesses who are put on the stand who have testimony that might be sensational and of interest to these outlets. And then they are there for the verdict, to give people the finality, the actual end point to what has happened. And that's kind of what I see here, that there's some points in this where I think the media knows they want to have someone and they want to get reports out. But by and large, they're content to wait until the actual extradition ruling from the judge. And that might be where we find ourselves now, which is why it's important for all the independent media who are taking the lead. So let me just announce as we conclude here that on October 3rd, I have co-organized a panel. I've put together this panel with people who are going to be hosting an independent media panel with me. We're going to be coming together, independent media who have been working on all of this coverage over the last 3 weeks, and we'll be working throughout this entire fourth week. And so we've got Juan Passarelli, Taylor Hudak, Mohammed Almazi, and Tariq Haddad, and we're going to have Mary Kostakidis. All of these people who have done excellent work. Richard Bedhurst has agreed to be a part of this, and we're going to get together and have this panel that we think can attention from around the globe to talk about, to wrap up this case and look at everything that's happened over 4 weeks. Joe Loria is joining. Thank you for chiming in. We've got from Consortium News. There's probably somebody else that I've now, but we've got about 7 or 8 people who are going to be, and we're going to do this over 2.5 hours, split it up among us, share what we feel significant developments from the past weeks, and those people are going to share their reporting, and we'll talk about where things might go from here, and do it. Unfortunately, people in the States, it's going to be early in the morning on Saturday, October 3rd, about 7 to 9 a.m. in the morning. But we've got the for the London audience, there's going to be at noon that they'll be able to tune in, and then for Australia, starting at 9 p.m. So we have this scheduled so that there's a possibility to get across the entire world in and appreciate what independent media has done. And I'm glad that we've been able to put this together and host this. So I put that out there. I float that out there. I tease it. I let you know that that's coming. And there will be more official announcement in the next day here that you'll be able to share. So So thank you once again for following this report. I'm going to go put together my written report for the day, which if you would like to receive that in your inbox, you'll go to dissenter.substack.com/subscribe, dissenter.substack.com/subscribe. And to anyone who has been enjoying and appreciating these videos, I'll thank you for sharing. But if you want to keep these going through the rest of the week, you appreciate this coverage and you've got $1 or $2 to chip in, go to shadowproof.com/donate, as it says at the bottom, and we'll keep this up. We'll keep setting an example for the establishment media outlets whose short attention span means that if we're not talking about the tent in the embassy where Julian Assange's and his partner's babies were made, then we've lost interest, and we don't know if we're going to be able to find 2 or 3 minutes in our nightly news broadcast to communicate what's at stake in this case, because it's not salacious enough for us to talk about the state of U.S. prisons. We need something a little bit more tantalizing than people's rights being violated. So, okay. Thank you, everyone, for following this report on day 15. I'll be back on Tuesday on day 16 as we move through the rest of this 4th week in Julian Assange's extradition trial. Until then, goodbye.